we want to welcome, Rabbi Jacob Belinsky to the program. We had you on, and we want to talk to you about two things. First of all, you had a big victory uh, in an appeals court in Colorado, and you downplayed what happened, but you didn't win everything. You haven't won millions of dollars. Your kids aren't coming back. That's true. But you have gotten a lot farther than most people have with a federal lawsuit that's related to a child custody case. And you filed this on your own. So first, explain what you filed. And you, even though you're not a lawyer, seem to understand what the case law was. So you were very careful about exactly what you were asking for. So explain what you were asking for and why you asked for it that way. And then you recently were arrested. We'll get to that. We'll get to the arrest second. But first, the federal lawsuit, what happened there and what you did and when.
Sure. Thank you for having me on. Can you guys hear me all right?
Yeah. Yeah, go ahead.
So I filed, I actually have 3 pending federal lawsuits currently, but I filed 2 federal lawsuits, one back in November of 2023 and one back in December of 2023. The first one was what I term or what I call the relocation crime spree, the relocation of my children, basically the finalization of their conspiracy to parentally kidnap my children and move them to Florida. The second lawsuit was what I called the false criminalization crime spree, which is where they attempted to falsely criminalize me for a forward text message asking to speak to my daughter, following actually an appeal win with respect to the restrictions between me and my children. The actual appeal came back and said they should have never restricted my time with the children. And then immediately following that, they started engaging in all this further fraud and false criminalization. So those 2 cases I filed in late 2023. I only asked for monetary relief because I knew that oftentimes these types of cases are dismissed on Rooker and Younger abstention grounds.
Now let's talk about that. So one principle, they call it Rooker-Feldman, is you can't go to federal court because you didn't like what the state court said. So how you did go to federal court, how did you deal with that principle, and why did yours satisfy that, whereas others, and often that's exactly what happens because of that.
Well, they originally claimed it didn't satisfy that. One of the things I did in my lawsuits, which were very clearly pled, I said, I basically disclaimed any interference with state court proceedings. I'm not looking to overturn any orders or interfere in any kind of state custody matter or criminal matters and so forth. And I specifically disclaimed those types of things. And I sued the judges in their individual capacities only. I sued the state in its corporate capacity, which remains to be seen how that's going to play out. But the reason why I kind of downplayed it, Mike, when we talked a little bit about this, quote unquote victory or win, it is a big deal to overcome the Rooker-Feldman and Younger abstention doctrines, and I hope it can help other parents and other victims of injustice as they figure out how to navigate and maneuver the federal system. But I'll give you an example. Now, after the cases were reversed and remanded, I immediately filed for document preservation and data preservation notices back in, I think, August 11th. I filed motions to lift discovery stays, and they never addressed them. After the appellate court in the 10th Circuit reversed and remanded and the mandate came down, then just a couple weeks ago, some of the defendants filed what they called renewed motions to the motions to dismiss. And I immediately filed a response and objections because what really should be happening is that we should be going to discovery. When a appellate court says further proceedings, it means to move ahead on the merits, and it means to go ahead into discovery and so forth. Typically, that's what it means. Well, just yesterday morning, I received 2 orders from the Chief Justice Philip A. Brimmer, who's the subject of multiple complaints, not just by me, but by other parents and victims of injustice, including a whistleblower complaint by me, I've tried to get him recused multiple times. He refuses. And anyway, he filed orders adopting the renewed motions, reinstating a very unusual move, reinstating the motions to dismiss from 2 years ago, reinstating the motions to dismiss, and did it across the board, even with defendants who didn't request it, and did not address any of my motions to.
Now you can go back to the appeals court having that appeals court victory, but the more you win, the bigger a deal it is. But it is a big deal because lots of parents go to the federal court looking for relief, and there's only a certain kind of relief you can get. And the more victories that are created, the more of a roadmap it is for other parents. And once you start to get victories at the federal court, that helps a lot in terms of exposing family court. So hopefully you'll get even more victories. But even if you lose everything going forward, it is a significant victory because the appeals court has said that your lawsuit had some merits, so it can be used by others. But well, I agree that they're going to use their own little legal tricks, but now you can go back to the appeals court and say, look, they're ignoring your order now.
Yeah, but see, the state and the government, they have all the time in the world. 2 years have already elapsed almost since the start of these cases, and it took an entire year for the appellate 10th Circuit to come back with that ruling, which should have been a very quick and easy ruling. And that was part of the reason for my whistleblower complaint to the House Judiciary, Jim Jordan's committee, was because the judges fraudulently added words to suggest that I was requesting adjudication of a trial, quote, in the state court. They added the words in the state court, which was completely fraudulent and fraudulently manufactured abstention grounds. So I argued that, and they reversed it. But the thing that they reversed it on, or one of the things, major things they reversed, they said the court did not determine whether or not these cases fell into any sprint category. And the sprint ruling has to do with
that's a legal standard. Explain.
Well, it has to do with the type of case, whether or not it's considered. There's a number of categories. I don't have it in front of me right now, but they could come back and say, well, we didn't determine what the category it fit in. Well, we think it fits into the third category. Now we're going to dismiss your case again, or they're going to say, well, we reinstated the motion, so even though they didn't preserve the arguments on appeal, even though they didn't cross appeal, even though they advanced on this abstention stuff, now that it was reversed, they could go back and say, well, we're going to look at the immunity grounds now. We're going to look at the failure to state a claim grounds now. And they could just, within a couple months, this could be dismissed again, and I'd have to go back to the appellate courts or do some sort of a special petition or mandamus or something talking about the law of the case and how they're basically subverting that and how they're not allowing this case to proceed and so forth. But it's just, these things take years. They take years. And what might be a good segue into the next section or whatever, what you wanted to discuss about the arrest and so forth, has to do with the fact that the prosecutor, so in the second case, we actually have federal court hearings tomorrow in both of those two cases. And the prosecutor, one of three who were sued in the second case for this false criminalization, she's actually going to be defending her personal conduct tomorrow in federal court. And then 1 week later, I'm going to be prosecuted by her on a probation revocation, attempting to put me in jail for a year. So today I'm talking.
Rabbi, before we get to that, a quick question about the other case. I don't want to tie it to the new case. I want to tie it to the old case. Who is Judge Dinsmore Tuttle?
Judge Dinsmore Tuttle is a senior district court judge who was specially assigned to my this criminal case for a forward text message, have daughter call me, after several judges who were being sued basically recused themselves. Anyway, she imposed an unconstitutional sentence on me, classified this forward text message as an act of domestic violence, gave me two years of probation, which should be supposed to be coming up in April of next year, of this coming year, and she right now is facing misconduct complaints that I had filed against her months and months ago, back in the early part of this year, and she's she's still holding on to the case. I actually have a Rule 35 post-conviction proceeding challenging her unconstitutional sentencing, and she's presiding over the very case, the Rule 35C case, challenging her own unconstitutional sentencing and conviction. And now she was also assigned to the probation revocation and the next criminalization case, which she'll be in court.
You're going to court, and we're going to talk about the second case. But she's still your judge. She has not been recused. She hasn't recused herself. She hasn't been removed. She's still sitting as the state court judge in your case.
Yeah, in fact, on the committee complaints or the complaints that I filed against her, she was actually the co-chair of the actual senior judge program, reviewing and the senior judge complaint program and process, the very complaint program and process that she's under. And the state court administrator swept that under the rug. And I have another lawsuit against him and the state court administration for public records because the fact that they will not acknowledge or provide me any documentation on the complaints I filed against Judge Tuttle. So I've got 4 lawsuits pending right now.
Before we go down that rabbit hole, quick question so we can segue to the second part. We all know that there's something called the petition clause to the First Amendment, right? You know about the petition clause?
Right.
And that says you can petition the courts for grievances. And part of that is if you file a case, you have to do due process. You have to give notice and an opportunity to be heard. You're aware of that, right?
Sure.
And so you have a case now in the Supreme Court of the United States. So tell us what happened with your case in the Supreme Court, what it is and what happened.
So the case, I actually have 2 cases in the U.S. Supreme Court, which are actually going up for conference on September 29th. One case is against the state of Colorado for the denial of certiorari on the criminalization, the conviction, and the underlying protection order as being void. The second case is against my ex-wife, who was the respondent in my petition for writ of certiorari to the district court in Colorado, and that was denied. And then when it went up to the Colorado Supreme Court, there was a fully briefed appeal directly to the Colorado Supreme Court. They waited 6 or 7 or 8 months, and then they denied it with 1 line. So both of those 2 cases are up at the Supreme Court. The one with my ex-wife, I was told by the clerk. I was told by the clerk of court. I tried to do an alternative service motion. They told me there's no provision for that, and that I was required to serve my ex-wife in that case. So I filed.
What did you do after you received the instructions from the clerk of the United States Supreme Court to effectuate service?
So rather than potentially rather than potentially risk the possibility of being accused of some sort of improper contact, I served, or I had the sheriff's department use the civil service through the sheriff's department to serve her the Supreme Court case.
So let's back up. She resides now in Indian River County, Florida. That's correct?
Yes.
And so you contacted the Indian River County Sheriff's Department to effectuate civil service of a United States Supreme Court case upon her. Is that correct?
Correct. Yeah.
So then what happened?
So about less than 3 weeks ago, I was arrested during one of my probation meetings for this 2-year probation on the forward text message to my daughter, and that conviction regarding domestic violence that's being challenged in multiple forums. And anyway, I was in my probation meeting, and all of a sudden they had sheriffs show up, and they arrested me under this statute, under a Colorado statute, for failure to comply. Apparently,
what was the basis for your failure to comply?
The basis for the failure to comply were primarily 2 things. They basically said that there's these multiple cases now out of Florida against you. My ex-wife made a bunch of allegations claiming that I was stalking, intimidating through third-party contact and so forth. And also given the fact that I had made records requests to obtain educational records on my children, and somehow these FERPA requests, which are federally protected rights, somehow also, were.
So let's back up a second. The basis for your illegal contact with your wife was through the sheriff's office. You actually petitioned the sheriff's office for relief, and then again through a Freedom of Information Law education request. Those are the basics. So these are legal avenues that you're entitled to petition the court or petition the government for. And the government is now holding this against you as a basis for a criminal violation.
Yep. Sadly,
hold on, Rabbi. They are claiming that you trying to serve your ex-wife, who has this order of protection against you, that service violates the order of protection. Am I right?
Correct. Yes, they're suggesting that.
Let me track it back. It seems like your story, the 4-word text message. What were the 4 words that you sent to your daughter? What were those 4 words?
Have daughter call me. Those were the 4 words.
It seems like your case has some similarities to this Fishman case. That you're violating protective orders by trying to have contact with your children. Am I right?
Yeah, absolutely.
These are not the only 2 cases where people are being put in jail for trying to have contact with their own children. These aggressive, draconian, and downright abusive protective orders are being used as a pseudo custody order, and mothers and fathers are being jailed for it. So, did I hear you right? You were meeting with your probation officer when some cops showed up. I don't know if they kicked down the door, maybe they opened it politely, but they arrested you during a meeting with a probation officer. Is that right?
Basically, the probation officer, it was a setup. It was a setup because that week I told him, I said, hey, I'm having trouble finding a ride to probation. Can I please have a virtual meeting this week? And he's like, no, you absolutely have to come today or tomorrow, whenever it was. And he knows that I've been, completely destroyed by the state. They've taken away my driver's license. I don't have transportation. I'm homeless. All these things, and I don't have any source of income. Anyway, he has me come to the meeting. We have this full long meeting. It was a setup, and then right away after the meeting, all of a sudden there's 2 sheriffs standing in the doorway of his office there to arrest me. He had filed a probation revocation complaint. They used this draconian statutes claiming that it was failure to comply. So and it was also, it was kind of crazy because there was numerous falsities in the report, in the probation revocation complaint, making all these false claims about me. And they recommended a $10,000 bond. And so I was put in jail immediately. And basically, knowing that I'm indigent or that I'm impoverished by the state, I don't like the word indigent, but knowing that they basically,
Can I challenge you on that? You've worked your whole life. Explain why can't you find work somewhere? You always worked. Okay, you got some legal problems. You worked before then. Maybe you won't make as much money. How come you can't get a job now? What do you mean you've been impoverished by the state? Are you saying no one will hire you? Why you worked before? It's not like you never had a job. So what is it that's keeping you from working now?
So look, I worked in Jewish context all my life. Okay. And I ended up in Colorado after moving back from Israel. It's a long story. And then that's when the divorce happened 10, 11 years ago. And I was working I was doing online work for an Israeli Jewish organization. And the type of work I do it's not, listen, I'm not opposed to working hard and to, flipping burgers, so to speak, if I had to. But the problem is that, look, the fact that they've taken away, they've basically, taken away my home, taken away my car, my driver's license, my bank accounts. They've levied everything against me. I have absolutely nothing left. So by the grace of God, by the grace of good community members, people that I know in the Jewish community, I do volunteer work on a regular basis on a Jewish organic farm. And as part of that work, I get kosher meals, I get temporary lodging during the week, and then I switch off and I go to my synagogue on the weekends occasionally, and I do other things. But I mean, listen,
So you have a job.
But
and not only that, let me finish.
Rabbi, can I make a point here before you say anything else?
Yeah.
I think that you have the workings of a 1983 case here. And what you have is a situation, you just talked about how they took everything from you. Now they're trying to take away your vocation. They're trying to take away your profession, and it relates to your First Amendment right to free exercise. At the end of the day, they shouldn't expect you to do anything other than be a person of God, because that's what you've been your whole life. You were a rabbi. You're not a congregational rabbi right now, but you could be a congregational rabbi. This would be the same thing as the government telling a journalist that they can't exercise their First Amendment free press rights. They're telling you as a man of God that you have to do something other than be a man of God. In religions, I'm not familiar fully with the Jewish religion, but I know in the Catholic religion, there are people that take vows of poverty and Carmelite vows, obedience. The government cannot step in the way of a religious vow and your religious vocation. And that is what I think this probation office is doing to you. So I would urge you strongly to consider seeking counsel to bring a 1983 case against the probation office in federal court, because they are violating your rights, your religious exercise rights. And the Supreme Court of the United States has come down on the side of religious rights most recently. And I think you have a very strong claim here.
Yeah.
And hold on, Rabbi, before you go on, 1983 refers to a section of the Ku Klux Klan Act passed under President Ulysses S. Grant. If someone under the color of law violates your constitutional and civil rights, you can sue. So that is what Richard Luthman is talking about. That's actually very popular, and I find it interesting that it was passed.
My lawsuits that were reversed and remanded are actually 1983 lawsuits, and is in addition to other statutes under 1981, 1985, 1986, and so forth. But the 1983 civil rights, that's definitely something to consider. There was two other like added on counts to the probation revocation, which they said, well, he hasn't sought employment and he hasn't paid his probation.
What about, hold on, when they said you haven't sought employment and you say you volunteer, but if they let you live rent free, you're not volunteering. The rent isn't free. You do work and then you don't pay any rent. How are you not seeking employment?
There's no direct exchange there. I mean, but yes, you're correct.
There is. You do work and you get free rent. What does that mean? That if somebody else lived there and they didn't work, that person would be
Michael, that's 100%. That's 100% wrong. You're looking into a place that the government says they can't look into because he's dealing with a religious ministry here. Okay, and it's very, very different. It predates the Constitution itself. It predates the Republic. It predates all of that. It goes back to the common law relationship between the church and the state. It goes back to Henry II and Thomas à Becket. It goes back to things that in our common law foundations and religious foundations, you cannot inquire into that. There's no way that the state can inquire into that. So you don't even have to answer that question, and you don't even have to justify that question, Seal, and that's the point. That's the harm we have here. It's a disgrace.
Well,
it's an unadulterated disgrace.
Hold on, Rabbi. I just want to add that we have name dropped Henry II, George Washington, John Adams, Bill Clinton, and Ulysses S. Grant so far.
Robert E. Lee. Don't forget Robert E. Lee.
Go ahead, Rabbi.
No, so to the credit of the people, the lovely people who have been assisting me, they would allow me to stay and be a part of the community, even if I didn't volunteer, even if I didn't put my time in. But we're all moved to help each other, to help to a greater goal and a greater cause. So all I'm saying is, look, it's not like a direct exchange, because they would allow me to stay during the week, or they would provide me with food if I needed, or whatever I would need. In addition to, I also get like a kind of a stipend, small amount of, per month, basically to be in this role of assisting spiritually or with questions on law and stuff like that. It's so it's not like I'm working. And not only that, but look, ever since this whole thing started, since my ex-wife filed post custody decree motions and so forth, starting 6-7 years ago, I now have been involved in something on the order of 35 plus cases. Okay, 35 plus court cases, and that's a full-time job in and of itself. Having to manage and having to defend yourself. I haven't had an attorney. The first 2 years I had an attorney, and I ended up having to spend upwards of $300,000 When they finally, tapped me out, then I started representing myself for the last five or so years. And so, but I've had all these cases, so it's not like I'm not working. It's not like I'm not trying to be productive.
Right. I wanted to add, this is Neil Shelton, a friend of mine. He was a very successful entrepreneur. Then he got divorced. He went to jail a bunch of times, and he continued to work, but it wasn't as an entrepreneur. He was basically like doing handiwork, that sort of anything that he could get his hands on. He eventually dug himself out. But that's what the process does. And then you are punished by what the process does to you. And Neil is a very hard worker. That's why he became a successful entrepreneur. And now they're punishing you for what the process did to you. Go ahead.
Yeah. I mean, basically, it's kind of ironic, today is actually Constitution Day. Mm-hmm. And I saw a video by the Supreme Court justices of the Colorado Supreme Court talking about the Constitution and how, liberty and freedom for all, and, no man is above the law, and the rule of law, and so forth. And two of them are being sued in several of my lawsuits. But the state of Colorado is criminalizing lawful, trying to comply with lawful order, trying to comply with orders. For example, the Supreme Court case, to have to serve Supreme Court service of process under the petition clause, and following rules of the court. There was no intent to stalk or intimidate or whatever they're trying to claim now. And now they're pushing to revoke my probation, which is supposed to be up in April of this coming year. And they're asking for full jail time on the original charge of a 4-word text message. After the fact classification of domestic violence.
It sounds like they are retaliating against you for
retaliation.
You think, absolutely. Rabbi, do you believe that someone else in a similar situation that didn't have the wins in the federal appeals court and the other cases that you have would be in this predicament?
To be perfectly honest with you, I don't think they discriminate. I think they try to, they do all kinds of things to good parents. But yes, I think given the fact there's an aggravating factor there, that they're, that I'm getting closer and closer to exposing more of their misconduct and to actually gaining some ground in federal court. It sure seems pretty conspicuous
on that note, Matt Grant said he was detained last week. And he claimed now, and I reached out to the St. Louis County Prosecutor's Office. They didn't respond. He claims it was for continuing to keep a copy of his federal lawsuit online, which doesn't seem illegal. I asked St. Louis County if that's true. They haven't responded. I didn't think it was true. I'm thinking it's a lot more true now, given that they won't say that it's so true.
Now,
so,
Mike and Rabbi, have you contacted the Indian River Sheriff? Or I think it may be something for me and Mike to do. Contact the Indian River Sheriff, or have you placed lodged a complaint against your ex-wife for a false report? Because I know under the Florida statutes, you can file for the waste of police resources. I had a situation like this. I was on probation, and I had a situation like this with the maniac called Christopher Ambrose up in Connecticut. And I was reporting on Christopher Ambrose's pedophilia and psychopathy, which is documented. And Christopher Ambrose called the police down here on me. He went to Jack Drum in Connecticut. Jack Drum called the local Florida sheriff, and they paid me a visit and said that I had criminally libeled Christopher Ambrose. I turned around and went in and I brought in some of the evidence that I have of from his computer about the downloading of child pornography and everything else. The lady assistant sheriff's jaw dropped, and then I turned around and told her I'd like to make my own complaint for a waste of police resources. So have you sent anything over to Indian County showing the Supreme Court case, showing the docket, and having them look at into their civil branch to file a criminal complaint there to protect yourself?
It's a very astute suggestion, and something that I haven't really thought about. I did contact Indian River Sheriff's Office to try to obtain the documents related to the stuff that they cited in the probation complaint. I was able to obtain through discovery. There's like, I don't know, 5 documents, 3 incident reports, and then a criminal summary. The thing that they told me about, though, when I contacted the detective there, finally reached her, she told me that because I was trying to obtain, they said they claimed there was a warrant out of Florida for my arrest. And I asked them, can I please see a copy of this warrant? Can I please get a copy of it? And she says, no, I'm not authorized to give it to you. And besides the fact that no judge has authorized it yet, it's still a pending criminal investigation. which is why I.
You don't even have a detached neutral magistrate under the Fourth Amendment that has made a probable cause finding. This is a probable cause finding by a cop based upon the word of a biased witness who may have perjured himself. Is that what we're dealing with?
Yeah, that's what it sounds like. Yeah, it's a very good analysis. I think you're right. I mean, I think
your recourse right now is in Indian River. I think maybe I'll give a phone call down to them. Maybe Michael will give a phone call or an email and find out what's going on in Indian River when they have, on one hand, the civil people are actually the ones doing part of the activity. They've become a witness in this case. And part two, I don't think that they can prosecute you in Indian River County because of the sheriff. They would need a special prosecutor at this point because of the facts. I think that some of these questions have to be raised with the sheriff and maybe the county prosecutor or the state attorney's office in Florida.
There's an important point to note too here is the fact that, this is the same sheriff's office who accepted my service of process, which included a statement.
Why wouldn't they? Why wouldn't they?
Why wouldn't they? Well, because
that's standard. Sheriffs serve people. I don't know if it's every sheriff. That's how I served my ex-girlfriend. Why wouldn't they? Nothing you did was unusual. That's the point I'm making. Nothing. It was routine. You had a lawsuit. You needed to serve a party. They lived in Indian River. You went to the sheriff's office. That is routine. Why wouldn't they? That's what dozens of people every day probably do at the Indian River Sheriff's Office.
There's another aggravating factor that we haven't discussed that I need to mention here is that I was not aware of this, but apparently my ex is under what they call the ACP program, the Address Confidentiality Program. So they were trying to claim that somehow or other I unlawfully obtained her address and
well, how did you obtain it?
How do you have? No, it's not even that. Don't even answer that. How do you have notice that she's under the confidentiality program prior to your service of Supreme Court of the United States documents?
I didn't. See, that's the point. I didn't. I was never served anything to tell me she was on some sort of address confidentiality system.
You have two process issues here. Let me finish though.
Let me finish though. The point is though, is if she was under this whatever program they're claiming it is, then why didn't the sheriff stop me and say, "Oh, this is a protected party under the address confidentiality program. We can't serve you for her." No, instead they served her twice for me, right. And that didn't say anything.
Right. All of these things seem to be alleged violations after the fact, based on routine things that you are completely entitled to do. And look, if somebody has a protective order against someone else, almost always, if not always, the process of the legal process that's separate, that is a carve out to any kind of a protective order. So you are still allowed to serve them. They are still required to go to court on a custody matter or something else if there is one. So they seem to just be making up law to screw you. And yeah, it seems to be a retaliation. And we'll find out if Matt Grant was really detained for keeping up a lawsuit. That seems to be retaliatory. You guys are winning in federal court, and they don't like that. That's what this looks like.
The probation officer, by the way, also in two separate instances in the documentation that came out in discovery, on one instance he says, I don't know, and I don't know if service to the sheriff it would be considered a violation of the protection order. And then less than 48 hours later, he says, "Yes, this is a violation. Let's violate him. Let's arrest him."
It's not a violation.
There's no judge that's looked at. That's the crazy part. We have a Fourth Amendment, all right, a detached neutral magistrate. You have due process issues. You have full faith and credit for the actions of other states.
And so in that way, it's similar to what Rich and Marta Bryceland went through, that people are bypassing a judge and arresting people, judge, jury, and executioner on these things. We got a lot of patterns that we're finding with your case and other people's cases. Well, Rabbi, we got to wrap it up, not this second, but in the next 5 minutes. Anything else that people should know about your case?
Well, I just want to reiterate the fact that the prosecutor who's attempting to prosecute me to put me in jail, tomorrow is going to be in federal court in defending her personal conduct in her individual capacity, and then in a week from today or from tomorrow, I will be in court by the conflicted judge and the conflicted prosecutor, that with them attempting to put me in jail for potentially up to a
Them
year.
putting you in jail seems to validate the lawsuit that you have filed, and you're probably going to have to amend it at some point to include what they just did.
You need to file a motion to disqualify the prosecutor office immediately, the office itself and the prosecutor, because the office, I think, because the sheriff's involved with the fact pattern, you need an independent prosecutor, number one. And number two is to go in front of Tuttle, you need to do a motion to disqualify her as well for recusal and put it on the record, law and facts, why she thinks she can stay on this case. You need that all in immediately.
So they actually assigned me an attorney for this particular criminal matter.
You're a public pretender. You're a better lawyer than the public pretender, Rabbi. You won at the 10th Circuit. The public pretender never won at the 10th Circuit. I would go with you every
Here's
time.
the thing. The public pretender's office actually conflicted off of any cases of mine. I never had a public pretender in my conviction trial, in the trial on the forward text message. I defended myself because I wasn't expecting the trial would go forward because they were being sued at that moment, at that time. But they conflicted off the case, and the Office of Alternate Defense Counsel, and a very reputable attorney took on the case. He does post-conviction work. I'm not, trust me, I don't, most attorneys I don't think are reputable. But listen, the recusal.
He's got the Colorado equivalent of Todd Bussard in the Paul Boyne case. That's what he's got.
All right, go ahead. Go ahead, Rabbi.
As far as the recusal goes, I tried recusing this Judge Tuttle 4 times. And I followed the statute and the rules. I filed 2 affidavits against her with 2 independent parties, and she denied it, ignored it, denied it.
Move to articulate, move for facts.
I went to the Colorado Supreme Court even to try and get her recused, and they denied it. So
move to articulate right away. Articulate. Ask for articulation of the law and the facts of why she believes that she's not she can be impartial, and part B, that there's no appearance of impropriety after you've won at the 10th Circuit. That's what you have to say. The appearance of impropriety makes her have to go. She can't sit on this case. It looks like it stinks. Even if she's 100% right and she's a good person and you're 100% devil, it still looks like something's wrong here. So she cannot be the one that sits there for the appearance of impropriety.
All right, go ahead, Rabbi.
Yeah.
All right. Anything else you wanted to add?
Well, I actually a friend of mine set me up a GoFundMe page, or a Give Send Go account. I work very hard. I'm not like some slacker who's not working or trying to, I work many hours a week on volunteering.
We'll make sure that link is in the description if anybody wants to help you out. I'm done with my questions. Rich, you got any other questions?
I'm done. Get that stuff in. We'll call Indian River. You should inquire with Indian River. That's what your relief is going to be.
Listen, this stuff is amping up because you are part of a movement that is winning more and more. The momentum behind reform, there's a headwind behind reform. These task forces are on one end. You are not the only person winning at federal court. And I know you haven't won the entire case, but you did have an important victory in federal court. And it's all coming together at once. There are laws, as we talked about from the Texas law, coming together. So I'm very confident that all of the things you've done are not in vain, that maybe you won't help yourself and your kids, but you're going to help a lot of other kids, because this stuff is going to stop. And what you've done will help it stop. And we will be back next week.